Corporations offer unique benefits, but what happens when they face financial trouble? Today we're exploring Corp bankruptcies and personal liability, a crucial topic for small business owners and shareholders. Corporations are special business entities that allow profits and losses to pass through to shareholders, affecting their personal tax obligations without direct corporate income tax. This structure provides tax advantages but can complicate matters in bankruptcy situations. When an S corporation faces overwhelming debt, it has two main bankruptcy options. Chapter 7 involves liquidation of all company assets to pay creditors, typically resulting in the closure of the business. Chapter 11, on the other hand, allows for reorganization and continued operations under a court-approved plan. Now, let's address a key concern: personal liability. Generally, S corporation shareholders are not personally liable for corporate debts. This means your personal assets are usually protected if the business goes bankrupt. However, there are important exceptions. If you've personally guaranteed any corporate loans or debts, you remain responsible for those obligations, even if the corporation files for bankruptcy. Additionally, in cases of fraud or misuse of the corporate entity, courts may pierce the corporate veil, potentially holding shareholders personally liable. Bankruptcy also has significant tax implications for S corporations and their shareholders. Any debt forgiven in bankruptcy may be considered taxable income. If the corporation is liquidated, shareholders might realize capital losses, which could offset other capital gains on their individual tax returns. It's crucial to understand that certain tax obligations, like payroll taxes, may be prioritized in bankruptcy proceedings. Choosing between Chapter 7 and Chapter 11, bankruptcy depends on the corporation's financial viability. If there's a realistic path forward, Chapter 11 allows for debt, restructuring, and continued operations. However, if the business has no feasible future, Chapter 7 liquidation may be the appropriate choice. When an S corporation files for bankruptcy, an automatic stay is put in place. This immediately stops all creditor collection actions, providing breathing room for the business to present its financial details to the bankruptcy court. Understanding these aspects of S Corp bankruptcies is crucial for small business owners and shareholders. While the corporate structure generally protects personal assets, exceptions exist and tax implications can be significant. If your S corporation is facing financial difficulties, consulting with a bankruptcy attorney can help navigate these complex issues and determine the best path forward.